I've been speaking out a lot recently about the dangerous shifts in our laws, which are designed to protect female victims, but would actually deny men their basic rights. And we're seeing another big push in New South Wales with a raft of proposed laws. And here to talk to me about that is Lorraine Finlay, who's a law lecturer at Murdoch University in Perth. Welcome, Lorraine.
Hi, how are you?
I'm great. Very nice to have you here. What we're talking about here are these proposed enthusiastic consent laws. And I think we should go back and talk about when this big push developed. And it followed on from a really ghastly Four Corners program run on ABC television, which involved a case where a Sydney man, whose name was Luke Lazarus, was found not guilty of sexual assault. Maybe, Lorraine, you can tell us a little bit about that case.
Sure. Well, I think the starting point is to note that anybody who saw that Four Corners story would just be appalled by what happened. It's a horrible case, and I think the victim demonstrated enormous bravery in the way she came forward. So I can understand why the New South Wales government is wanting to do something to avoid what happened in that case from happening again, because what we saw in that case was, despite it being accepted by both the jury and the trial judge after the appeal that there had been sexual contact between the two, and despite it being accepted that the victim didn't consent, the accused in that case, Luke Lazarus, was ultimately acquitted because it was found that he didn't, couldn't be established beyond reasonable doubt, that he didn't know there wasn't consent. So to establish at the moment sexual assault under New South Wales law, you need three things. You need the physical act of a sexual assault, you need the victim not to have consented, but you also need the accused to have known that there wasn't consent. And that was the real issue in this particular case.
Yeah, and what was really ghastly, it was anal rape. She was very young. She was on her knees in a laneway, totally drunk. As you say, anyone watching that would have felt incredibly sorry for her and annoyed, angry that this man got off.
Absolutely. It's a heartbreaking case. And what makes it even worse is she had to go through 2 trials and 2 appeals. So the legal process itself really aggravated the problems in this particular case.
Absolutely. But as a result of that, what's happened now is the Law Reform Commission has been asked to reconsider the sexual consent laws. And now it spells out this issue of enthusiastic consent as something they should be considering. Is that right?
That's exactly right. So what the Law Reform Commission has been asked to look at is the issue of consent under the New South Wales law. And in particular, they do seem to be looking, and certainly the Minister is suggesting that they should look at this issue of enthusiastic consent, which is also known as affirmative consent, or yes means yes laws, as they're often termed in America.
Yes, and they haven't been introduced anywhere in Australia as yet. Is that right?
Well, Tasmania has something that's very, very close. So Tasmania has a free consent position, which are probably the broadest laws in relation to consent in Australia. But certainly in America, there's been a concerted push to introduce these types of laws, to the point where about 1,400 higher education campuses now across America have within their codes of conduct yes means yes standards for sexual assault cases.
And then that's, of course, what's extraordinary about this. Not only has America gone down this path already, but it was sufficiently long ago in America for us to see where this heads. And I've talked before about the fake rape crisis on campuses, where we absolutely charged down the same road as America followed like 20 years ago, even though we could see the repercussions for universities, which were then dealing with the consequences of cases where the universities were found responsible for not protecting the rights of young men who are unfairly accused under the tribunal set up in America. Now, this is the same sort of thing. I was going right back, actually. There's a college called Antioch, I can never pronounce that, a college who over 20 years ago in America introduced similar sort of standards requiring verbal consent every inch of the way, every sexual activity, and right through that sexual activity, they required, usually the woman, to be given consent. And they were rubbish from one end of America to the other at that time. And in fact, the college closed down. They lost all their applications for enrolling in the college dropped off enormously, and they ended up, it put them out of business, which I thought was really funny. But that hasn't stopped people, of course, because across America now, as you say, colleges are introducing this standard regarding consent. And Australia is, despite being a globalised world, Australia is pretending this hasn't happened, pretending we can't see where this will lead, and is pushing to have similar laws introduced in Australia. Now, go on, Lorraine, sorry.
So that's the really difficult thing here, because you can clearly see the good intentions that lead you down this path, because we all want to make sure that somebody who's suffered a horrific sexual assault actually sees justice done. Now, we don't want a situation where sexual assault victims feel as though they can't report the crime, or if they do, they won't be believed and they won't see their accused brought to justice. But sexual assault cases lead to a really delicate balancing act, because on the one hand, you need to create an environment that gives justice to victims, but on the other hand, you also have to protect the due process rights of an accused. And in sexual assault cases, it's particularly difficult because of the nature of the crime. You generally have an offence which is committed behind closed doors in a private or semi-private location, where there generally aren't eyewitnesses, and where what you really have are often two very different accounts between people as to what actually happened. So it's a he said, she said type of scenario. And the difficulty in terms of physical evidence is that once there's been sexual contact, the physical evidence or the difference between consensual and non-consensual contact in terms of physical evidence is actually often non-existent. So it's a really difficult offence to prove, because you're relying purely on the testimony of the victim as opposed to the testimony of the accused. So striking that nice balance, or an appropriate balance, between believing a victim and protecting an accused is really difficult.
And often, this may be a couple who've had intercourse before. I mean, it can be a boyfriend-girlfriend situation where clearly the physical evidence won't apply. I mean,
absolutely. And what you see in America as well. So what you see in America increasingly as well is it's often a drunken hookup type of situation, where what actually happens is the following day, people see those events in very different light to what they did at the time. And, you know, in America, there are some extraordinary statements, for example, by a Title IX officer at Washington and Lee University, who effectively said, or actually did say, regret equals rape.
Yeah, and so these are regret sex cases. Yes, that's right.
That's exactly right. And I think you're getting to a really dangerous position where you broaden out the concept of rape to such an extent that having a bad sexual experience or a regretted sexual experience, as, you know, sad as that might be, and as much as we don't want that to happen, to say that that's a criminal offence that could lead to the imprisonment of an individual, that's a really big step to take.
Yes, and as I understand it, even legally, sometimes the laws are written in a way that allows the woman to retract consent, to change her mind about what actually happened. Is that right?
Oh, well, absolutely. And even as the law is at the moment in New South Wales and Western Australia, where I am, it's very clear that you can withdraw consent at any point along the way. But what we've seen in practice with the affirmative consent type of notion is that people are particularly able to look with retrospect at what happened and change their mind after the fact about whether they consented or not. And that's an entirely different thing that's really quite dangerous.
Yeah. Now, can you take us a little bit through why is this such a problem? What are the legal issues emerging as problematic in relation to affirmative consent laws in America?
Well, the way consent works in Australia at the moment is, and there are slight differences across jurisdictions, but for example, in New South Wales and Western Australia, we talk about consent that's freely and voluntarily given. And what that means is it's effectively a no means no type of standard. So we start from the position that sexual contact is consensual, and it's only if you can prove beyond reasonable doubt that there was no consent that suddenly you have a criminal offence emerging. Yes means yes turns that on its head. It means that you start from a position that the sexual contact is not going to be consensual, and it's only if you can positively show that there was consent given at each and every step of the way that you actually avoid criminal liability. So in effect, what it does is it reverses the onus of proof, because it means that an individual accused is now required to show that at every step along the way, they actually got or were able to prove there was enthusiastic consent to what they were doing. So the biggest concern with this is the due process issue, that it really moves away from that idea of being innocent until proven guilty and starts from a position that sexual contact is problematic until you can show at each and every step that every single contact that occurred was specifically consented to. And then the second problem, which isn't so much legal but practical, is that that's just not how sexual relationships work. So to require somebody to verbally consent at every point and say, yes, I'll let you kiss me now. Oh, yes, I'll let you touch me there now. That just takes away all of the natural spontaneity that occurs in a sexual relationship between people. And what we're seeing in America is the practical impact is really great, because it actually does mean after the fact people can change their minds about whether they'd consented or not to a particular sexual contact, and that leads to a huge number of problems.
Because it means that most sex is rape. I mean, that's the consequence of this. Most of the sexual activity most of us have would be non-consensual, because very few women say yes, yes, yes along the way, and nor do we want to. But that leaves the man liable. And of course, it absolutely shifts the responsibility totally onto the shoulders of men. And that's a real problem, isn't it?
And I think the thing that encapsulates it for me is affirmative consent standards make for a great moral code, but a bad legal standard. So morally, of course, we want all sexual contact between people to be absolutely consensual. We want everyone to be as enthusiastic as their partner and to get as much enjoyment as their partner in the sexual relationship that they're having. But to put that into a legal context, you're really creating a situation where there's a huge grey area. And so somebody entering into a sexual relationship doesn't actually know at the time if what they're doing is going to be considered legal or not legal. And there's just no clarity around the standard.
No. And it absolutely cuts across all our normal sexual mores, the way we actually interact in terms of dating, the assumptions men and women make about what's appropriate behaviour. I did this online dating coaching for a long time and talked to endless women about their expectations, for instance, about whether the man would kiss them and so on. I think very few women would have been comfortable with a man who said, may I kiss you? They expect the man to take initiative. They were often annoyed if he didn't, and that's what, regard him as very wussy if he was to keep asking for consent. I mean, I think it is so realistic and crazy. And as the media has tended to point out in terms of the discussion around these campus laws in America, and yet, the lawmakers, the administrators have continued to go down this path. And there have been big cases in America where it's all come unstuck, haven't there?
Oh, absolutely. I mean, we just have to look most recently, the case of severe intoxication in relation to Doe and the University of Michigan, if I'm remembering correctly. Yeah. And, in that particular case, it was quite extraordinary because you had both a male and female who were both severely intoxicated. Now, the university code at that university says that if you're intoxicated and somebody engages in sexual contact with you, that's a sexual assault, because effectively they take the view presumptively that you cannot consent if you're severely intoxicated. Well, then what happens in this type of situation when both of the people involved were severely intoxicated? And the problem in that case was it was only the male who was subject to charges, and the judge in that particular case, when it ended up going to court, actually found that an unacceptable standard had been set by the university that no accused could ever meet because they were having to prove their own innocence, and that in fact the male in that case had been denied equal protection under the law because he'd been in exactly the same situation as the female, but only he'd been charged.
Yeah, absolutely. And I think that's happened a lot. There is an assumption, if you look at the sexual consent courses that are being run in our universities, that they explicitly state that if a boy, a young man and woman are both totally pissed, he is responsible and she's not. And I just find this so extraordinary. There was another case I found very amusing, actually, a University of Cincinnati case where both the male and female student had this sort of drunken hookup, and he woke up terrified that she was going to file a sexual misconduct claim, and he rushed into the office and filed one against her. And she was found guilty and was suspended. I mean, I actually think this is probably a really good idea for young men to get in first and see how they go, because, I would have thought legally that in most, I don't know, what do you think about that? Would it stand up in Australia if the young man was to take that action?
Well, you'd hope you never get to a situation where that happens. And just to go back for one moment to the earlier case, I should just clarify, it's actually Miami University, not the University of Michigan. Yeah. So that's my error there. Right. But the case in terms of Miami University just demonstrates when you have situations where men and women are on a college campus and they're both drinking, I mean, to suggest that that's something where we want to have a law that applies to one but not the other, you're just getting into a situation that is incredibly awkward. And the criminal law is a really blunt tool to use in those situations, because to call someone a rapist, that's something that carries an enormous stigma in our society. And what we see in all of these American cases, and if I go back to one of the most famous cases where false allegations have been made in America, that's the case, obviously, of the Duke University lacrosse team back in 2006. That entire team was stigmatised based out of the allegations that were made. And in that particular case, when the charges were dropped, they weren't just dropped, but the Attorney General actually ended up proclaiming that the individuals were innocent, which is incredibly unusual. So I think in these cases, while we start from a position that we want to protect victims and make sure that victims can see justice done, we simply can't ignore the fact that sometimes false allegations are made. And sometimes, even if there aren't false allegations, what we have is simply a disagreement between two people about exactly what occurred and a misunderstanding about the signals that were read. Now, that's not something you want to have happen, but whether we should impose a legal standard that criminalises that behaviour and can lead to imprisonment, and in all of the American cases have led to students who've been expelled from university, who've lost scholarships, who've been unable to work, who've been publicly shamed. That's why the criminal law is always so strict in Australia about due process, because we need to avoid those types of consequences unless we're sure beyond reasonable doubt that a crime's actually been committed.
Yeah. I mean, I want to show people a recent video made by Janice Fiamengo, who I often talk about, wonderful professor of English from the University of Ottawa. And she's recently made a video called Feminists Lose Another Trial. And she's talking there about the Ottawa, a similar case to the sort of thing you've been talking about, Lorraine. This is an Ottawa University hockey team. And two young men were charged with sexual assault over 4 years ago. And, the whole team was stigmatised. I think they disbanded the whole team for a long time.
The team coach was fired.
Team coach was fired. They're all disgraced. And, of course, the university feminists uses this as an excuse to, produce innumerable measures to deal with this rape crisis on campus. And it was always presumed these young men were guilty. And then now a female judge, interestingly, has found the accused, the accused not to be guilty. And I wanted, so I'm going to play Janice Fiamengo talking about this case. What was interesting, it was a complicated case in a sense in that involved sexual activity involving the accused, young woman, the accuser, young woman, and two of the hockey players, where she first has sex with one and then has sex with another, and it's particularly the second boy, the second young man, who is accused of sexual assault. And in fact, the first young man conspires with the accuser to present what happened in a particular way. And the judge ruled that, the young woman had actually lied in the way the whole case was presented. Anyway, let's listen to Janice Fiamengo talking about that, because she's tied up in that is also, of course, this issue of enthusiastic consent, and that's what I want to hear you talk about. So we'll just run a bit of that now.
The defense position, in contrast, was based in legal common sense. The defense case was that the accuser's behavior clearly indicated consent. She did the same things with the second hockey player that she'd done with the first, and she acted in the same manner. In other words, she gave consent through her actions, even enthusiastic consent, according to witnesses. And she definitely never said no or indicated in any other manner that she didn't want to participate. But according to the Crown, none of these facts should save these two men from prison. All that is relevant to determining non-consent, according to the prosecutor, is what the accuser tells us about her state of mind. As he said, quote, "The notion of consent is not based on what other people saw or perceived. It is based on the subjective state of mind of the complainant." And further, quote, "It is not a defense to ask whether the complainant sufficiently expressed that she did not want to engage in a sexual act." I don't think one can exaggerate how illogical and unhelpful such premises are as a basis for criminal law. That sexual consent has nothing to do with observed behavior, and that the accuser need not say no for the sex to be deemed assault. Such a standard is contrary, in my opinion, to any common sense understanding of human sexual behavior. And it is also outrageous in its pretense that adult women can't be expected to be able to say no to sex they don't want, though these same women apparently should have the sole authority to send men to prison based on their after-the-fact reconstruction and reporting of an unknowable thing, such as their state of mind.
I think Janice has absolutely nailed that, as usual, talking about what this issue actually means in terms of responsibilities of men and women. There was something else you wanted to mention, Lorraine, in relation to that case.
Yeah, absolutely. What was really interesting is after the case, one of the women's rights activists or advocates, Julie Lalonde, who'd been involved in doing some work at the University of Ottawa, actually came out with some extraordinary statements, one of which was, every time we see a high-profile sexual assault trial result in an acquittal, it sends women back 50 years. Now, I just found that extraordinary, because she's suggesting that any time the criminal justice system works and actually acquits somebody who's innocent of a crime, that's actually a terrible thing for women. I would have thought that what we actually want for women and men is to have a criminal justice system that ensures guilty people are punished and innocent people are acquitted. So there seems to be this idea amongst some women's rights advocates that a criminal justice system only supports sexual assault victims if we get a high conviction rate. And that's absolutely the opposite of what we want a criminal justice system to do, because it's actually really easy as a prosecutor to get high conviction rates. You simply have to, firstly, just convict everybody, and then there's no problem. So throw due process out the window and just find everyone guilty. Or secondly, you only prosecute cases that are slam dunk cases. What we actually want is to have a criminal justice system that's fair, both to accused and to victims, and that the community can have faith in. And that means there will be acquittals, but the mere fact that there are acquittals doesn't mean the system's failing. Hopefully it means we've actually struck the right balance in what is a really difficult area.
Well, what's interesting, I was talking to a prosecutor the other day who was telling me they're under such pressure to put every, sexual assault case to push every sexual assault case into court, and they're really nervous that if they turn around and say there wasn't enough evidence to proceed with that one, they'll get criticised. And so they're pushing through cases that haven't got enough evidence for them to achieve convictions, and they still get constantly criticised whenever there is an acquittal. I mean, it's a total no-win for the prosecutors, isn't it?
Oh, absolutely. And as a former prosecutor, I can say with absolute certainty that sexual assault cases are amongst the hardest that you'll ever prosecute because, of course, you are dealing with the word of one person against the word of another, and you're dealing with issues that have enormous emotional impact on people. And, if we go back to the Four Corners story that we started with, you can see that quite clearly. When you're listening to the young lady talk about what happened to her, she says the biggest thing coming out of the trial when there was initially a conviction was that she felt she'd been believed. Well, one of the things coming out of the case, I don't think anybody disbelieves her, but it's one thing to say we believe a victim and we think something terrible has happened, and it's another thing legally to say we think a criminal offence that deserves criminal sanction has been committed to a standard that's beyond reasonable doubt. And the reason we have that standard at the criminal law isn't because we want to make life tough for sexual assault victims, but it's because we've got that fundamental principle that, it's better for 10 guilty men to go free than one innocent man to be convicted. And I know I've misphrased that, but the basic principle that you need to be innocent until proven guilty and that we err on the side of caution because of the seriousness of a conviction, that's a really important principle that we can't afford to lose.
Now, let's go back to the Law Reform Commission's investigation of this. People can make submissions to this, and that's why I've done this video. I really want to encourage people to get involved, because what's worried me is the public discussion around this issue has almost all been in favour of these new proposed laws around enthusiastic consent, and hardly anybody dares speak out against them. Yeah.
Which is interesting in itself, because when you look at America, for example, there are some really powerful groups and very serious groups and commentators who are opposed to these types of laws in America. So, for example, the American Law Institute recently voted down an amendment that was designed to insert affirmative consent requirements into the model penal code. I mean, that's a serious group of people. There are eminent professors in America, the National Association of Criminal Defence Lawyers. There are some very serious people who are opposed to these laws, and yet in Australia, we haven't really seen that yet. There's not been a lot of discussion about it that's been anything other than positive about going down this path.
Yeah, that's because feminists control the public discourse in Australia, and anybody who dares to challenge it gets torn apart by our media as well. I mean, it's just extraordinary to me. I mean, yes, I'm noticing the American Law Institute issued a very strong statement saying consent may be expressed or may be inferred from behaviour, including words and conduct. This is the point. As we all know, it is quite possible to interpret people's behaviour in terms of consent, and the assumption that it has to be verbally expressed is simply absurd, as most normal men and women would acknowledge. And as the initial discussion around the introduction of these sort of laws in colleges, I mean, even the media then was on board saying, how is this going to work? This isn't how normal people behave. And yet these laws are proposing to totally take what we regard as normal sexual behaviour and turn it on its ear. So tell me about, so I'm trying to encourage people to get involved. Now, where is this commission's hearings? What stage are we up to? What can people do? Are you making a submission, Lorraine?
Well, I'm hoping to make a submission. The Law Reform Commission in New South Wales actually had a deadline for preliminary submissions on the 29th of June, so that's closed. But what will be happening is they'll be releasing a consultation paper at some point in the future, and we don't have a definite timeline for that. And what they've said, and this is all available on their public website, what they've said is that once that consultation paper is released, which I suppose will frame the discussion and let you know a little bit more about exactly what they're considering, there'll be an opportunity for consultation and for people to make submissions. So that's the point at which I'd hope to make a submission. I'm sure you'll probably make one as well. And I'd encourage anybody who's listening to this who has concerns, whether from a legal due process perspective or just from the impracticality of these types of standards, I'd encourage everybody to make a submission, because at the moment, you know, we're seeing out of the Four Corners story an understandable attempt to address what was a horrific event. But, you know, difficult cases don't lead to good legal reform. And pointing to those really hard cases where you wish things had gone differently, that's not actually a good basis to make appropriate, balanced legal reform. And I happen to think that the laws we have at the moment in both New South Wales and WA, you know, they're not easy to understand all of the time, because we're dealing with human behaviour. It's hard to know where you draw that line in terms of consent. But I think those laws strike a really fair balance in terms of looking at the really difficult issues that you're dealing with whenever you're talking about questions of consent.
I have some really wonderful material that certain organisations in America are pulling together regarding what all the law professors are saying in America about this issue, some of the really good editorials, you know, so they're gathering evidence that will be really useful for people in making submissions. And I'll put some of that up below the video in the low bar.
Well, and if I can just flag as well, they have a lot of evidence as well about what proponents of these types of laws are actually aiming at. And I found one particular extraordinary bit that I might just grab from you, which is by a journalist in America called Ezra Klein, who's a former columnist with the Washington Post. And he's written an article back in 2014 that says, "Yes means yes is a terrible law, and I completely support it." And what he basically says in this column is these laws go too far. They will inevitably criminalise people who shouldn't be put in that situation. But, and I'll just quote from this, he says, "No means no has created a world where women are afraid. To work, yes means yes needs to create a world where men are afraid." So he's coming out and effectively saying we need to have these laws that I know are going to result in some innocent people being horribly affected and even jailed. But that's important to strike fear into the hearts of young men so that we don't have this rape culture continuing. I just think that's an extraordinary approach to take, because he's actually quite openly saying we want to go too far with these laws in order to, sorry, that's just my mobile phone going in the middle of it that I forgot to turn off.
Go on.
But he's actually saying that the value of these laws lies in their overreach. And that's just not acceptable in a criminal justice system.
Well, let's put that up too for people to see. Yeah, I mean, I just think it's really important that ordinary people, not just the lawyers, get involved in this discussion. And we show that there is strong public opinion about continuing down a sensible course in relation to this complex issue, rather than always kowtowing to the feminists.
Absolutely. And I think the other really important point to make in all of this is that if we're looking at sexual assault laws, changing the law is only actually one method of impacting upon the environment. I mean, again, going back to that phrase I gave at the beginning, affirmative consent is a great moral code. It's a really bad legal standard. So of course we should be encouraging people to ensure that there's consent and to make sure that they're not taking chances when it comes to sexual relationships, but to enforce that in a legal code is a different thing altogether.
Yeah. I mean, I've talked about sexual consent courses in the universities, and what they leave out is any responsibility on women to clearly convey consent. And that's the other part of this story that's never discussed. To say yes clearly, to take responsibility for making a decision about whether they want to go to bed with someone or have sexual activity with someone, rather than, getting totally pissed and getting carried away, which is what lots of young women do. So that's the other point
to make there is if you dare suggest to women that they should take responsibility for their conduct in terms of not putting themselves in dangerous situations. So talking to young women about the fact that perhaps you shouldn't get severely intoxicated at a particular party so that you won't know what you're doing and you'll be in a dangerous situation. It's not victim shaming to say that. I'm not saying that any woman who's severely intoxicated is asking to be assaulted. Of course they're not, and they should expect that they're not going to be assaulted. But you can say to women, there are things you can do to help make yourself safer. And I don't think that you're being anti-woman or anti-victim if you put forward suggestions like that.
Absolutely. Lorraine, I think we better stop there, but it's been wonderful talking to you, and I hope we've managed to encourage a lot more people to get involved in this really critical debate about the next step in what could be tilting laws away from fair treatment for men and women.
Absolutely. Great talking to you.
Nice to talk to you, Lorraine.